Hi, everyone. Welcome, and thank you so much for joining us today for our webinar. My name is Serena Bhatia. I'm a senior staff attorney with the Children's Immigration Law Academy, or CILA. We're just going to jump into the swing of things and with a quick introduction. So today we will be discussing record requests in the Special Immigrant Juvenile and related adjustment of status context. Before we get started, I'd like to discuss some brief housekeeping matters. This webinar is an hour and a half long. Please enter your questions in the Q&A box instead of the chat box. We are reserving some time for questions at the end. And this webinar will be recorded, or is already recording now, and will be posted to the CILA website at a later time. We will also provide a copy of the PowerPoint presentation as well as a handout of resources. Following the webinar, we will provide a survey for feedback. Please do take time to complete that as we really appreciate and do listen to your feedback. Okay, I would like to first introduce our guest speakers. We have Emily Creighton, Legal Director of Transparency at the American Immigration Council, Raul Pinto, Senior Staff Attorney, also at AIC, and Theodora Dora Saclarides, Project Coordinator at the National Immigrant Justice Center. Just a quick, very brief reminder of who CILA is. We are a project of the American Bar Association's Commission on Immigration. And we are based in Houston. And now that we have expanded to nationwide, we provide technical assistance. We offer working groups and provide trainings such as this one, and also written resources. With that, I'm going to hand it over to our wonderful guest speakers. Thank you all so much for being here, and you can take it away.
Thanks so much, Serena and CILA, and I'm so happy to be here along with my wonderful co-panelists. I wanted to sort of kick us off, and we can just move to the next slide, with some basic understanding about the Freedom of Information Act. So we're going to be talking in this presentation about a variety of ways to obtain records. And I think that we'll be delving into some hypos, and we'll be talking about different ways to obtain records from different immigration agencies for your clients. But I wanted to focus a little bit on FOIA, and I know the ORR records request process is a little different, and Dora is going to be focusing on that. But I wanted to just kind of kick off here with a discussion about the basics around FOIA. So FOIA really has some lofty goals, which I think is helpful for all of us to keep in mind as we do this work. It really is about promoting a more open and transparent government. The purpose of FOIA in some of our work and most of our work is to obtain client records. So the Freedom of Information Act, we've sort of shoehorned our immigrant records requests into this statute, which really does provide a lot of leeway and really is a generous statute, and should be interpreted to benefit us and our clients, and that we're asking for information that we typically have a right to. So it's just kind of a reminder that FOIA is our law, it's our statute, and we should be able to obtain documents and records through these different provisions. And as a starting point, it is about transparency. So I just want to really drive that point home, because I think sometimes it all becomes very transactional and sort of mechanical, but we really should be using it to our advantage as much as possible. So under the Freedom of Information Act, any person has a right to request records or information from federal agencies. And the statute also establishes other requirements like deadlines, which we're all aware of, the 20 to 30 days, typically. Well, that is what the statute says, and we'd like to see records within that time frame. It's not common with various agencies to actually see the agency meeting that standard, but that is what is required under the law. And any person means any person. Your immigration status has absolutely nothing to do with whether or not you can obtain records under FOIA. And when you're using FOIA, and we'll talk a little bit more about this and about how to reach out to specific agencies, you're going to be requesting things like your A file or your client's A file from USCIS, entries about entries into and departures from the United States from CBP. You might be seeking, though probably not in this context that we're talking about today, broader, memos, policies, practices, and procedures, that sort of thing. The agency has to provide these records to you. That is a requirement under the law, as long as they are reasonably described. This second box here that talks about what you have to say about the records to receive them. So you have to reasonably describe them. That really should not be limiting in any way. And if the agency needs more information from you, they are required to come to you and ask you for that information. They can't just say, I don't know what you're asking for, it's confusing. They are required to come to you to perfect the request, to seek more information so that they can conduct a search for the records that you were requesting. An agency, I think we all know this, and we'll be talking about the various agencies that matter to us today, includes any of the parent agencies and the component agencies. So for example, Department of Homeland Security and the DHS Privacy Office is an agency, but also the subcomponents are considered agencies too, like CBP and ICE are all components of DHS. And ORR would be a component of HHS. So I want to talk about one thing that, just as a reminder, is a lot of information is available on agency websites. Typically not things that you'll be looking for, records you'll be looking for your client in the context that we're discussing today. But as a reminder, agencies are required to provide some information proactively on their website. So you can find things about like agency organizational structure and some of that information on a website. You can find information that's been released under previous FOIAs on the FOIA library on various agency websites. So I would, if you're looking for policies and memoranda, you can scan to see if there's anything there that might be helpful to you prior to any request. Again, that is not about immigration records specific to clients, but for you to understand that some of these agencies do actually provide some information that might be helpful to you on their websites. They have to make the records promptly available. I think we'll be talking about this today. We'll be asking some polling questions about how quickly folks are receiving documents. Promptly available. So just to quickly explain what I mean when I say they have to respond within 20 to 30 days. Well, that doesn't mean they have to provide the documents within 20 to 30 days. They just have to respond to your request and say whether they're going to grant it or deny it. Typically, the agency will just provide the records in their first response to you, because by the time they're searching for the records and producing them, it's sort of a fluid process. And so there's not this formal sort of, we've received your request, we plan to respond to it. Typically, they'll begin producing records around the same time that they're responding to your request. And different agencies have different response times, which we'll talk about a little bit as well. Okay, we can move on to the next slide. So these are just some of the records that we're going to be talking about today that you have encountered, you will want to obtain to understand better how to represent your client, what relief might be available to your client, what immigration benefits they might be eligible for. And so today we'll be delving a little bit more into this. The A file, which you would request from USCIS, CBP encounters, how you might go to OBIM and CBP for some of that information. OBIM is the Office of Biometric Identity Management. Raul is going to be talking a little bit more about how to request records from OBIM later. There's some new processes with the Executive Office for Immigration Review at DOJ, and that's for asking for the record of proceeding from an immigration court. And some of that is a new process. We're sort of curious to hear how that's working for people. We've been getting mixed reviews. Removal orders and state and criminal records. We'll be talking about that a little bit more as well later in the presentation. So I'm going to go ahead and turn it over to Dora now to take us through a hypo, just to sort of help us wrap our minds around how different records requests will be happening throughout the life of a case.
All right, thank you so much, Emily. So I will just be leading through everyone through a hypo that may lead to these kinds of requests. So let's say that we have a client, her name is Maricela. She is 16 years old and she is from Guatemala. And the time frame of this case is from the beginning of SIJS through to AOS. And this is the initial scenario. So Maricela has been released from the OR shelter. The LSP that originally did screening did not think that there would be an SIJ case. So you have an intake with Maricela for release representation. She's very shy and says things were just fine at home, and unsure where to go from there, you ask for her permission to get her OR records and file a request for OR records. So story continued. You receive OR records that include notes from Maricela's clinician indicating that Maricela was left with her grandparents when she was 3. So she calls her grandmother Mama and her grandfather Papa and doesn't remember her biological parents, but spoke to one of them by phone occasionally. And in the OR record, there is mention in the notes of an SIR, serious incident report involving drug use, but there is no copy of the SIR in the record received. And when you speak to Maricela, it turns out that she disclosed trying pot in Guatemala before she left. You ask her more questions about her family based on the clinician notes and determined there was abandonment by biological parents as well as neglect. Also in passing, Maricela mentions that she came to the United States with her younger cousin, who is now in a different state with a different relative. And Maricela doesn't seem to be in removal proceedings, but you will need to get in touch with prior counsel to find out what happened. So you obtain a state court order, file an I-360, which gets approved with deferred action, and now it's just waiting for a visa. So story continued. 5 years later, Maricela's visa number is about to be current. You reach out to get her in to start her AOS paperwork, and you already think a FOIA should be done because she came with her younger cousin. Perhaps there's smuggling concerns. So you file a FOIA with OBIM and CBP, and the FOIA result reveals multiple entries, so you have to do a waiver. And then when it gets to the part of the intake where you are asking about criminal history, Maricela says she remembers an incident with some friends. It was late at night. She was in a car with 3 other friends. 2 of the kids were smoking. There may or may not have been drugs in the car. Police pulled them over because of a broken taillight. She remembers being in the back of a police car, but she thinks she never made it to a police station. She just went home. And she doesn't remember giving fingerprints at any point. But because of this update, you decide to get an FBI fingerprint check and any local checks. And when you are going over the I-45, you realize that you don't know what happened with her with her removal proceedings. So you look her up in EOIR's automated online system, and it says the case was admin closed. The notes in the file of Maricela's former attorney indicate OPLA affirmatively dismissed the case through prosecutorial discretion. So you submit a request for the record of proceedings to find out what happened in her removal proceedings. And when you get the ROP, you realize that there is an asylum application included and some indication that it was also filed at the asylum office due to Maricela being an unaccompanied child. And before you file the I-45, you need to figure out what happened to the asylum application. So you file a request with USCIS. Given the hypo, as you can see, over the course of time in working on this client's case, there was the necessity to file many different kinds of requests to receive different kinds of government applications in order to, obtain information about a client's given case. So just in the next couple of slides, I will be talking a little bit more about OR records, how to request them, information that will be included in OR records, and possible challenges in obtaining OR records. And as you can see at the beginning of the hypo, There was uncertainty about, how to start with the case since Marisela, she, initially began stating that there are no issues at home, but then obtaining the OR record, there were more detailed notes about how her parents, or who she called her parents in home country, were not actually biological parents, and that led to the beginning of her SIJ case. Care providers are mandated to maintain these kinds of files, and they must be available to ORR at all times. And does a child have an OR file? Yes, they should. So if a child was designated unaccompanied and placed in OR custody, they should have an OR file. And even if a child was later transferred to DHS custody, OR records from earlier periods in OR custody can be requested. It is important to note that if a child was detained in family detention with parents and was not designated unaccompanied, they will likely not have an OR file. These children should instead follow the standard FOIA process to obtain early government records. And, at least at NIJC, this is a standard practice that we do for all of our clients. We request, and it's a recommended practice, we request OR records for all of our clients, even if it's, at the start, it isn't believed that we're missing information or if there are concerns. We do not do this for all of our detained children, but only for those that we represent, detained and non-detained. And we do so because obtaining an OR file is important to support a child's claim for legal relief. As you can see in the hypo, in filing a request and obtaining the child's OR records, it immediately became apparent that there was that the child, possibly had legal relief for SIJ. And although there are many protections for unaccompanied children in the United States, there is no policy preventing OR from sharing documents with DHS, which is concerning. So obtaining OR records is also important to be aware of any negative information that could adversely affect a child's legal case. And in the second and third bullet point, there are very useful guidelines that I highly recommend that everybody consult. The second bullet point contains information. It provides a detailed overview about different kinds of information that OR collects about children in its custody. You can find this information under reporting and record keeping, and I'll also be giving a brief overview of this information in the next slide. And then the third bullet point contains a link to a guide that talks in more detail about how to obtain OR records. I will also be going over this, but once again, I highly recommend that for anyone who has questions to consult this resource because it is very helpful. Next slide. So this is a brief overview of different kinds of information that can be found in a child's OR file. Starting with basic biographic information. In an OR file, you can find a child's birth certificate, their photograph, their full name, their A number. You can also find a child's placement documents. So when they initially arrive at a given OR facility, you can find their intake placement, the inventory of property, legal information, which is definitely relevant to the work that we do. You can find a child's KYR acknowledgement form, EOIR court documents, criminal history records. As I said, we want to be aware of any information out there that could adversely affect a client's legal case. You can also find medical records and clinical mental health records. There are different kinds of assessments, such as sponsor addendums, individual service plans. You can also find a child's educational records. And this may not be so relevant to a child's legal case, but it certainly is endearing to see a child's progress in school and their given placement. There are also different case management records. This can include anything from case manager progress notes, recreation logs, family reunification packets, incident reports, which we talked about in the hypo, significant incident reports, grievance reports, and finally information about discharge and exit information. This can include anything from a child's verification of release and more information about different wraparound services that a child will receive upon release. And just to give more information about specific kinds of information that my team has specifically looked for over the years in filing these records, just to give some personal experiences. For given clients, we have filed OR records, for example, to specifically look for information regarding SIRs, which was mentioned in the hypo, but once again, we want to be fully aware of any information that could adversely affect a child's legal case, because once more, there is no policy preventing OR from sharing documents with DHS. We also request OR records to obtain the child sponsor's contact information or contact information for family in home country. So, unfortunately in our line of work, we have had incidences where, our legal team's relationship with the shelter is more adversarial, and the shelter is not always so willing to share information with us, even if it is something as simple as a sponsor's phone number. And this is especially challenging when working with a tender age child who can't tell them themselves, where their parents are, how to contact their parents, do not know their parents' phone number. So in obtaining an OR record, one can then access that kind of information to advocate for, it's especially useful in advocating for younger children. We filed OR records to obtain a child's birth certificate because we often include this in different kinds of legal filings. We often initiate representation with children who are experiencing prolonged stays in detention, because in obtaining a child's OR record, we can then see sponsor assessments and home study reports, which shine a lot of light on what's going on with the child's FR case. And it's especially useful once again if the shelter isn't so forthcoming about sharing information about a child in custody. And finally, we also, in the past, we have filed OR records specifically looking for information about a child's hospital visits and progress reports. So if a child is hospitalized, a shelter isn't always so forthcoming in telling us, why a child was hospitalized or what happened. So looking at a child's OR record can be very useful in finding more information about this. And thank you for going to this slide. In this slide, I'll be talking more about how to file an OR file request. And as I mentioned in slide 7, there is a link to a guide that provides more information, but here I will be providing, once again, just a basic overview. Please note that there is an updated ARR request form. The link to it is right here. And this information may be redundant, but just to review, the most basic information in how to request OR records. This form needs to be completed, and then this request form should be emailed to the following email address: request.bucs@acf.hhs.gov. And in the email, the child's full name and A number should be included in the subject line, and include necessary supporting documentation, such as a representation document. And this chart is really helpful in indicating what kinds of supporting documentation is needed. And you can see that for like legal service providers or attorneys that they must include a representation document. And it's also important to note that the representation document should be an L3, not a G28. And I'll be talking more about that in the next slide. And on a final note, in the guide that is linked to in slide 7, the guide indicates that receiving a request can take several months, but at least in NIJC's experience, we usually receive requests in less than a month. It is possible to expedite a request if a child has a hearing or an 18th birthday is approaching. Other reasons, such as asylum interviews and pending removal orders, may be accepted at the discretion of OR. If a request is urgent, you must put urgent in the subject line and indicate the basis for the expedited relief requests in the ARR form. And that's the basic overview for, thank you for providing this poll. And I know that I provided, my own personal experience at my organization, but I'm also interested in the input for of everyone participating in this webinar. For what timelines have you seen for responses to OR record requests? All right, so it looks like, most people haven't had, either haven't had issues or receive responses in under 3 months. So that's more or less the experience within my team. We haven't received, had the same issues as we've had with FOIA requests, which I know will be discussed later in this presentation. And then finally, moving on to the next slide. I just wanted to discuss different or like common issues in obtaining OR records. I'm drawing from personal experience, but also input from colleagues in my organization and also other LSPs. And I'm also interested in learning more from participants in this webinar. But one common issue that we face in obtaining OR records is redaction or missing information. But honestly, we more commonly see redaction with FOIAs and not so much in OR file request records. We will see, personal information perhaps crossed out. But because the procedure to request is outside the scope of the FOIA process, OR does not have to inform recipients if it withholds or redacts information or provide a reason. Furthermore, there is no right to appeal a denial of a request for an OR file. However, we do not commonly see denials. We will occasionally see, personal information crossed out. But a suggested practice is if information is missing, it may be because specifics were not requested. So for example, in the AR form, you will see that there's like a checklist of different kinds of information that you would like included in the response. And there is a check for a category that's labeled as other, and then it allows you to elaborate. So if you find that information is missing, it is recommended to check the other box and to be specific about what you are looking for. Another, perhaps issue or obstacle is requesting information without flagging possible concerns. And without flagging possible arrests or other concerns for a child, a suggested practice is to ask for information in the context of an SIR without tipping off that there are issues. So the key is to use general language. So this advice is a little bit different from the first bullet point where I say, be specific about what you're looking for. But in the second bullet point, a suggested practice is to be general and, perhaps ask for information within the context of an SIR. But it's also important to note that not everything may be found in an OR file request. So for example, if a child was charged with drug trafficking at the border, it may be best to file a CBP FOIA, and this information may not be found in the child's OR file. And another issue is signatures for tender age children. So according to the Department of Health and Human Services, a tender age child is up to 13 years old. Children above 14 must sign. If a child is under 14 and non-detained, a caregiver can sign. But if the child is still detained, OR retains their discretion as to whether to consent to release their information. And we've definitely seen this issue where we've had tender age children who are detained, their family separation cases, and to get parents' signature, we need to mail the signature pages to the given detention center where the parents are. So it just creates a lot more work, and it's definitely a challenge. And yes, thank you for pulling up this poll. So I'm curious about the experiences of other people in this webinar. Has anybody else experienced issues with who signs record request forms for children under 14? All right, it seems for the most part, no, but more or less down the middle. So I find that very interesting that other people have, also seen this as a common issue. And moving on to the last point, as I mentioned earlier, it's a pretty recent development. We're now in filing an OR file request, proof of representation is needed, whereas that was not a practice beforehand. And, at least within my team, we have received request denials if we submit the AR form with a G28 instead of an L3. And at least a suggested practice is the L3 asks for a lot of information, which, at least within my team, we don't always believe we need to provide. We don't need to provide more information to OR than what is needed. So we have adopted the following suggested practices for completing Section C, which asks for this information, namely, reasons for representation, timelines of representation, date of birth. So a few suggested practices in Section C2, selecting other and specifying that you'd be representing your client in immigration and other matters agreed upon with my clients. Once again, being general, not being so specific. And in Section C3, selecting other event and specifying that you will be representing your client until representation ends. Once again, being general. And another suggested practice is not including a child's date of birth. The identity of a child is confirmed by the use of the A number and name. Inclusion of a date of birth should not be construed as affirming the date of birth as listed in the UC portal. At least within my team, we haven't had any pushback in, being more general with our responses in Section C. But this is just an overview of common issues. And once again, I highly recommend consulting the 2 guides that are linked to in slide 7 for more information about obtaining OR records and the kinds of information that you can find in an OR file. So thank you for your input in regards to the polling questions regarding OR files.
Hi, everyone. Good afternoon. I'm Raul Pinto. Thank you for having me today. And I will be tasked with talking about getting to the nitty gritty of the FOIA request. You want your records, you want to complete the 485. We're going to contextualize this in the context of adjustment of status. We're going to be talking about the 485 a lot and how to answer certain questions. And so we'll get started with a OBIM record. And we wanted to ground our discussion today with the hypo. And so part of the hypo is you already think that a FOIA should be done because Marisela came to the United States with a younger cousin, and there are smuggling concerns. And so that is going to color what we are discussing. So you're going to file a FOIA with OBIM and CBP. Now, when we do these presentations, I always like to think about what is the strategy, what is it that we're going for, and what are the time concerns that we have upon us. With SIJS, specifically with unaccompanied minors who are now applying for adjustment of status, you're going to have, it's weird to say this in immigration law, but you have a little bit of the luxury of time, right? Because you've already submitted the I-360. And now for that, you're going to need ORR records, and it may be good to sort of know the history of the client. But for all of the details that are required on the 485, you may have a little bit of time because you'll have that sort of that wait. The client will be in deferred action according to the new regulations. So you'll have some time to get these processes going. So whenever there is a border encounter, I think it's going to be important that you at least do a CBP record search and possibly an OBIM search. We'll talk about sort of the distinction between the two. And I'll get started with the OBIM record. So OBIM is the Office of Biometrics and Identity Management that Emily mentioned before. OBIM is that branch that basically collects records. They're going to collect the fingerprints of your client. For another case that I've been working on, CBP, I can tell you that CBP is not very fond of fingerprints right now, and they're going all in on facial recognition technology. And so I would not be surprised if fingerprints are actually a thing of the past in the near future and they go to full-on facial recognition. That's a discussion for a different webinar, I guess. And don't ask me my opinion about that, but that's kind of scary, but whatever, we'll leave it as that for the time being. But in any event, OBIM is going to collect the fingerprints, but they're also going to collect that photograph, right? And so what you want to what you're going to know, what you want to figure out from OBM is has your client been fingerprinted? That's number one. But number two is they're also going to collect data about the time and location of where that individual was fingerprinted. So if you have any doubt about where the person entered, where the person encountered Immigration and Customs Enforcement, or rather CBP officers, right? You're going to want to do that OBIM FOIA. Now remember, the 485 is going to be very specifically ask you what is the point of entry, right? That may be the first instance where you are actually encountered with this particular question. But right, if someone is in removal proceedings and you're looking at the NTA, that actually where the person was encountered may also be an issue that you're going to have to litigate, and so that's going to be very important. So you may want to do an OBIM FOIA right from the very beginning on these kinds of cases in order to sort of corroborate what your client is telling you. And so again, it'll have the fingerprint, it'll have the date, and it'll have the location. So that's why the OBIM FOIA is so important. And the reason why it's so important, we've all, in previous life, I've represented dozens of SIJS clients, and when I asked them like, where did you enter the country, and I would go, and they're right. I mean, they were usually very young when they entered the United States, and so therefore it's very difficult to ascertain exactly some of the questions in the 485. And so that's why you want to do your due diligence and get these records so that you're better able to corroborate the information and give the most accurate information in these government forms. But I will also say that sometimes the information between that's going to be available in one agency may actually be available through a different method, possibly a quicker method. I know Emily's going to talk later on in the webinar about the A file and the type of information that is included in the A file. So sometimes if you can get, for example, if you have already admitted to the pleadings in removal proceedings, and that has the spot of where the individual crossed or where the individual was encountered, then you may not actually need to do an OBIM FOIA. So really you got to think about sort of tactically, what are you requesting and what you need it for in order to not to duplicate your efforts. So that is also important. As far as the process is concerned for an OBIM, you can do a written request, much like any other FOIA. I think the agencies are trying to really get away from the written FOIA request, although you still can, and I think there's addresses that are available for folks to submit a FOIA. They're really going into the portals, submit this electronically, and OBIM is no exception. So you can file the a written request, or you can go through the portal. If you file a written request, you may find information out there that you may need what's called a G639. I'm sure that many practitioners here are aware of that form. That form is not required. That form is not required to submit a FOIA request. And so I know that practitioners are sometimes a little skittish and get a little queasy because the FOIA request, the G639 asks for country of nationality, and we know that could be brought up again in removal proceedings, and so that could be a little problematic. I know that it also asks for information about the parents, and that could also present some problems in the context of SIJS. So you really have to think about whether you want to provide the information in the G639, because it does help the agency to process it, but you may want to look at it in a different format. Much like, for example, Dora had explained before that you provide the information in a more generalized form, so it can't be utilized against your client later on. The one thing that I will say about the OBIM is obviously because you're doing a biometric search, because you're doing a fingerprint search, you're going to have to submit that fingerprint card. Whether it's in writing, you submit the hard copy of that card. If you're submitting it through the portal or electronically, you're going to have to scan it and upload that card into it. And so the one thing that I will say that about that process, you got to be mindful that in some places it's going to be a law enforcement agency that's going to be taking the fingerprints. Not always. I've heard that some practitioners allow do their own fingerprinting. I've heard that before. They have other types of agencies that do the fingerprinting. So you got to be careful. I mean, if the individual has a record or something like that, where interaction with a law enforcement agency may not be the best thing for that individual, then you just have to be mindful of that you may be sending that client into the law enforcement office to get that process started. And so one of the challenges, however, with OBIM records, I think Dora hinted at this before, but you may be missing those records because CBP does not fingerprint children under the age of 14. And so if your client entered under the age of 14, then there may not be that record. They may have pictures though, and so that's another way why you would do a CBP record instead of and maybe even both, an OBIM record and a CBP record. So, but yeah, the policy was there was a notice of rulemaking that was published in 2020, but I don't think it ever made it to a final version, and so they're still only fingerprinting 14-year-olds and above. And so you have to be cognizant that you may not get that record even if you do make that request. Going over to the CBP records, the column on the right, the type of records that you're going to see are border apprehensions, obviously. And that's the main reason why you would do a CBP FOIA request, I think. In SIJS cases, you'd also do them for the interviews. If the officer interviewed the individual, sometimes the officers will use that information. It'll make it to the client's A file, and therefore that interview information and all of the client's answers may make it into whatever proceeding they are in. And so you have to be very cognizant about that. So that's why if you learn that the individual has been interviewed by a CBP officer when they came into the border, then it may be worth it to do a CBP record search as well. The CBP records are going to have expedited removal orders and entry and exit information. So sometimes worth it to do one. And that information may not necessarily be available in the A file. Let's see what else I can tell you about CBP. Sometimes it's in terms of process, it's sometimes easier to go to the web portal. Serena, if you can give me the next slide. Actually, we already talked about the OBIM and how to do it. So I already skipped a couple of slides as I was going to the presentation. So if you can give me the next one too. Here we go. So this is CBP, how to submit a request. Once again, I think you can do a written request. There are several ways in which you can do it. I like the portal. CBP portal has been good. They use what's called the FOIA online process. You can get updates on how the agency is doing with processing of the FOIA request. And in some agencies, actually, they even provide you with the documents within that system, and you can just download them. So I think it's a good way to go. You just have to be careful as to what the portal is asking you to fill out. The portal sometimes, and Emily's going to talk about this a little bit, but the portal sometimes will ask about country of citizenship, much like the G639, and because they're automated forms, they may actually not allow you to continue on with the process until you fill out that information. So you just have to be careful about that. If you don't want to concede anything in these forms, then you can think about a different way of submitting that FOIA request. Yeah, so if you can give me the next slide. And I think I'll kick it over to Emily to talk about EOIR records.
Thanks, Raul. That was a great overview. I wanted to just mention a couple things about CBP, which is, as Raul mentioned, the process. If you could go back one slide to the CBP slide, the process and for obtaining records from CBP is fairly well explained on their website, and that link that's provided on the slide talks about the process, and it also talks about the different records that Raul provided an overview. One thing to note, and I don't think this will probably matter in the clients' cases that we're talking about here because of the ages of the clients, but CBP doesn't have complete records of apprehensions by Border Patrol before the year 2000. So just to know that some apprehension records before that date, you're going to find only in the A file. And then Raul talked about other records that you would find by requesting them from CBP. And you'll also have like all sorts of things about entry into the United States, the I-94 records. And one advantage to the online process for CBP, I agree, you never want to give away or provide any information, nor are you required to under the statute, although some portals, and I'll talk a little bit about it with USCIS, require it for you to sort of move through the portal, in which case you don't have to use the portal. It does organize your records for you. So if you have, a docket of clients and cases where you're trying to sort of keep your FOIAs organized, the online portal will keep the correspondence, keep your correspondence, keep the agency's correspondence and records that have been produced. And you'll be able to check the portal and not worry about missing an email or something getting lost in the mail. So I just want to note that those are some advantages. Some disadvantages to the portal. One is just an irritating reality, which is that you have to continue to sign into these portals and they will kick you out, in which case, and this has happened to me many times, I'll need to call and have my account reinstated. It's just a sort of technical glitch that I think is just meant to drive us all nuts, but these portals are imperfect, is the idea. I do think, though, they're attempting to sort of move into more online processes that we need to be cautious about, as Raul mentioned, because you don't want to give away information or share information about your client that will harm them. Though I will note, we've been asked this many times over the years, whether releasing or revealing information to an agency to obtain records through FOIA, whether or not the information shared there has repercussions in terms of agencies taking some enforcement action against an individual. We have not, that has not been the case for the most part. I have not heard of that happening. I'd be very curious to hear if someone sees a relationship between information that was shared with the agency and FOIA responses. Agencies in various panels over the years and in conversations have emphasized that should never be the case, but it does not mean that we should not be cautious in the information that we share. I also wanted to note, and this applies to CBP and DHS subcomponents, except for USCIS. So CBP is one where apparently there's going to be a new system for processing FOIAs that's going to be implemented over the next few months. I think it's just important to know that the agency, and you'll see a notice if you go into this website for when you file your FOIA with CBP, they talk about how they're going to be changing the process. And what they say is that it'll impact FOIA processing. They'll give us advance notice. I see no advance notice there. I checked the website today. But that it may be necessary to pull your documents off of the website at some point, which sounds like sounds like there could be problems related to that, incidental to that, flowing from that. And so, the council would love to know if there are any issues, and if anyone observes that, documents have disappeared or there are any concerns around the new process, we very much want to hear about that. So I just wanted to add all that along with the CBP slide, just to make sure that folks are aware of some of that. And I think that, the overall message is that there are some advantages, but just words of caution as well. So we can move to the next slide. So, and I'm going to ask Raul to jump in, because I know that he's been following this closely, but I'll just provide a quick overview. So this is where in the hypo, and I think the CBP, the CBP slide relates back to the hypo as well. Here is where something happened in the client's case, and we're not exactly sure what it was. We just know that the case was admin closed. And so we want to go back and look at the record of proceeding. So prior to a few months ago, this was just a normal FOIA process, and you would go through the Department of Justice, EOR, FOIA process to obtain the record of proceeding. The process has now changed, and it's become through feedback from folks who are navigating this new process. It's continuing to be fine-tuned on the website, and more information and processes are being shared. But what the process is, it's just entirely outside of the FOIA process now. So you've always had a right to inspect your client's record of proceeding. And now the change is, and you have always been able to ask for that record of proceeding by email or by mail or in person. Now what you're going to do is go to the website, which is not included here on the slide. So I'd like to, I don't know if Raul can help me out by sharing in the chat. I also have it here. Is a process that I think is better described in the website than here on the slide. And it talks about how you can request records from each immigration court. So you can, and it actually provides a table of email addresses. So I just want to be clear. I don't think this fourth bullet here really provides the best information. I think you need to go to EOR's website and look to see how to submit to each immigration court. And so you're going to want to direct your email to the immigration court where the last hearing was scheduled for your particular case. And the immigration courts are listed there in a table in alphabetical order by court name. If your case is pending before the BIA, there's a different process, and you can also submit a request by email. And that process is explained there as well. If you want to go in person, you may go in person to request the record of proceeding, but you're going to want to do all the things that, are sort of common sense, where you can just confirm the court is open, and you can call the court, check the operation status webpage to sort of see if the court's in operation that day. The board does not accept submissions this way. You'll have to separately contact the board. Sometimes you'll be able to go the same day, but it's best to work out with the court in advance when you'll be able to go to obtain the record of proceeding. You're going to want to complete an EOR 59 request submission. This has been developed for this process. And if the file is for the file for an individual's file, or the file of a minor child, and you want to make the request in person, you bring identification that matches the name on the ROP, the record of proceeding, or the name of the parent or guardian of the minor child's record of proceeding. And you're going to need to complete that form. So we can move on to the next slide. I want to invite anyone. Raul, is there anything that you would like to add on that process?
No, just to say that the website that you're referencing, Emily, is the actual the EOIR's practice manual, the electronic one, and there's a section called Chapter 12, requesting records, and that's where you'll be able to find the information and the combination of court, the combination of the email for every court, because every court is different. So I'll just highlight that, and I'll try to put it in the chat as well.
Okay, great. I think there's also here, I'm going to share it here. I think if you go to that website, you'll actually see, you'll be able to link to a chart that provides each of the individual court email addresses. So I just want to make sure that everyone has that as well. Okay, so here we are. This is the next phase. And this is a process that I have sort of watched develop over the last few years, because I've been involved in a case where we've been forcing the government to comply with timeframes around A-file requests. And so back to our hypo, you get the record of proceeding, you realize there's an asylum application included, and some indication that it was also filed at the asylum office due to Maricela being an unaccompanied child. But before you file your 485, you need to figure out what happened to the asylum application, so you file a request for USCIS. So as we sort of covered it, I think Dora touched on this, the documents that you're looking for in the A file might include the I-360, biographic information, like a birth certificate, state court records of family proceedings. All of this might be contained in the A file. You're really not going to know, right, until you request the A file and receive all that information. And there are 3 ways to do that. You can request an A file by mailing the A file, a request for an A file by just asking for the A file in a letter that is mailed to USCIS, and that information is on USCIS's FOIA website. You can also request it through FIRST. FIRST is the online portal that has been developed only for USCIS, and so you'll need to develop an account there to request information about individuals. It does ask for country of citizen, country of birth, and so there is some information that you may not want to provide. You can't finish the application for a FOIA, for an A file FOIA request through the portal without providing some of that information. And that is why some practitioners are choosing instead to just continue to use the G639, where if you leave some of the fields blank, you will still receive information in response. Again, there are advantages to using the portal where you will likely receive your information more quickly. We have heard from practitioners that is true, that they are able to they're able to request and receive information relatively quickly and painlessly. Again, some practitioners very strongly feel that they should not have to reveal information about their client, and for strategic reasons would prefer not to use FIRST, which is a legitimate decision and choice. So I would say here, a couple things to note is that the FIRST process recently, only in the last couple of weeks, has actually removed a checkbox for the A file. So if you go through the process on the portal, and this is actually true for the G639 too, there's no box to check for A file. You need to, in the FIRST process, you need to actually indicate other. So it lists out a bunch of documents that you'll typically find in the A file, and you can certainly check all of them. But if you would like the entire A file with all the information in, which I think is, we hear anecdotally, is the preference. And I think that lawyers I've talked to, I think the responsible thing to do is to request the entire A file. Then you would have to click other in the portal and write in A file. That is the document that I am requesting. And you can also, there's also some space, I think 250 characters, to sort of better describe what you're seeking from USCIS. Just to note, I think many of you know that there are different tracks for A file requests. If your client is in proceedings, there's some information you can provide about scheduled hearings to demonstrate that you need to be placed on track 3 for a FOIA request for an A file, which will move your request along more quickly. All A file requests should be completed within 20 days or 30 days if the agency invokes an additional 10 days for processing, which it typically does. So if you are not receiving your A file that you have requested within the 20 to 30 days, I plead with you to reach out to the council, to me, and to let us know, because this is this is required under the settlement agreement in the Nightingale case that I've been involved in. So we really want to hear any information about USCIS not providing the A file. That's not true for other agencies and for other documents and information that you might be requesting from other agencies, but for USCIS, A files should be received within that period of time. Okay, and here we have a poll asking this question, because I'm very curious to know if this is something that people find confusing. And this goes back to what I was just talking about in terms of USCIS removing the box that allows you to just click, check, I would like an A file. I think our understanding and our belief is that USCIS has done this deliberately to discourage people from asking for the full A file, which is very problematic. So if you find it to be confusing or discouraging, it'd be helpful if you could fill out this poll and just let us know what you think. Or you might not be aware that this was the issue. Okay, it seems that a resounding yes in response to that question, which is going to be very helpful as we speak to opposing counsel about this issue. Okay, so I believe that we can go to the next slide. And this is something I've covered. So just so that you know, again, there's an entire new system, which I'm sure all of you who do this regularly are now familiar with, because it's been around for some time now, which is FIRST. And this is not going away. This is not going to change. And I guess the last point I'll make on this is that there is a push for people to use FIRST. And USCIS has said that it will no longer accept FOIAs by email on some future date. That will become the policy. It has not happened yet. And I think that would be really problematic if it does, but they have said that that is something that they are planning for the future. For now, though, again, you can submit a request in writing for an A file, just a letter or an email. You can use the G639 or you can use the FIRST system. And I will, we can move on. Oh, and we have another poll. This is where I really would like to hear if folks are here or getting their A file requests within the 30 days, which is again required under the Nightingale decision. Okay, well, this is interesting, and maybe folks can follow up with me separately. Again, this is about A file requests, not all requests to USCIS, but I assume that we're mostly talking about A file requests. So please let me know if you're one of these folks who says it's 3 to 6 months or 6 to 12 months. That's really problematic. Okay, I will move off of USCIS, which is something I could talk about forever, and send it back to Dora.
Thank you so much, Emily. I just wanted to provide, a brief overview of common issues in obtaining FOIA requests, and I believe that some have already been mentioned. One being the existence of records, as Raul mentioned earlier. CBP does not fingerprint children under 14, so that could be a possible issue of concern. Another is failure to recall details about immigration history. As detailed in the hypo above, it was over time that the client Marisela, she revealed different kinds of information about her history and her legal case, which impacts the kinds of FOIA requests that an attorney would make and to different government agencies. Juvenile state records may be sealed and may not be available to the public. I mentioned this concern once again in the slides about the OR file requests, the issue of requesting information without flagging possible concerns. And once again, the recommendation is to be general with language, not to flag possible concerns. Another possible strategy is filing a USCIS FOIA to get an entire A file. And prolonged timelines, as as you all provided your input in the poll, is an issue. Within my organization. We have seen that FOIA requests can take anywhere from 4 months to 1 year. Usually denials are received within 30 days though. And what is a real issue is that, sometimes we do receive FOIA responses long after a child has had their SIJ merits and we no longer, need the information. So prolonged timelines do affect our casework, and it is problematic. And moving on to the next slide, I just wanted to provide a few common issues in obtaining FOIA requests for tender-age children. And at least within the practice of my, my team and other teams at NIJC, it seems that the rules are not so clear-cut as in obtaining OR file records for children who are unable to sign for themselves. So in general, we evaluate this on a case-by-case basis. We have children sign if they understand and are capable of signing on their own. But we don't have an age cutoff, and per the FOIA manual, we understand that children can make requests themselves. They do not need certification of agreement from a parent or a guardian to make this request. But we still have had issues in having FOIA requests, denied if a child signs for themselves, but also we have had FOIA requests denied if, a person other than the child signs on behalf of the child. At least the recommended practice is for, a denial if, a guardian signs on behalf, the parents are absent, to provide proof of guardianship. This could be, attaching a court order appointing guardianship with verification of the guardian's identity. And of course, if, even if a parent signs, proof of relationship also must be submitted. And in general, a recommended practice is if one FOIA format does not work, checking that all requirements were met, and if they were, to look for another outlet. So for example, we've had denials where, we first filed and then we received a denial because, no proper identification was provided for guardians. So we resubmit with that documentation, and then we still get a denial. A last outlet could possibly be getting child's signature if somebody, signed on behalf of the child. So, this is an ongoing issue that my team has faced. Once again, we assess each situation on a case-by-case basis. And working with tender-age children does present its own unique set of issues.
So with that in mind, I wanted to talk a little bit about something that Dora hinted at previously, which is the state records issue, which is, the 485 asks you to list those arrests, right? Or any crimes that you may have committed for which you have not been arrested. And so you want to provide the most accurate information for that, and state records are going to be the main source for that type of information. So relating it back to the hypo, Maricela remembers that she was in the back of a police car, but she never made it to the police station and they just took her home. So she doesn't remember giving fingerprints at any point. And so our decision is then to do a FBI fingerprint check and a check for the criminal record at the local courts, right? If we have to boil this section down to one thing, is know your state laws. Availability of the records is going to depend on the state laws. And you want to look at how a juvenile can obtain those records, because oftentimes, as Dora was saying, those records are going to be sealed. If you can give me the next slide, please. So what basically that means is that you're going to have to figure out where are the exceptions to the sealing of the records, and how you get that information in order to provide the answers to the I-485. So for example, I'll talk about my home state of North Carolina. We regularly did this because there's an exception to the sealing of records for juveniles that allows for juveniles themselves to obtain the record. And so I would often just tell, if the client was 15, 16, go with your parent, go to the juvenile court, tell them what I told you, that under the law you're supposed to be getting those records, because sometimes even the clerks didn't necessarily know, and they would say that the records are sealed, but they would point them to the right statute, and they would be able to get their own records, so that you would be able to provide that information in the 485. I will say that there are several states that automatically expunge records. But remember that you're supposed to, even if it's expunged, you're supposed to provide that information in the 485. So you got to be very, very careful about how you are reporting those expunged arrests. Because if the record has been expunged, then you unfortunately will not be able to get it. It's going to be very, very difficult. Sometimes even I would go as far as telling the client, hey, look, if you've gotten an arrest, go get the record before it's expunged, or get me some kind of paperwork that at least explains that. The other issue that I was making sure that you all are aware about is that the juvenile age of delinquency obviously varies from state to state. In North Carolina, again, talking about my home state, until very recently, if a crime was actually committed and the individual was the crime was committed before December 1st of 2019, the age of jurisdiction was actually 16. And so even though the individual was a minor for immigration law purposes and for other purposes, that person was still going to be tried as an adult. And so you got to be careful what the age of jurisdiction is going to be there. If it's a juvenile, then you fall under the rules of what happens to records when it's done by a juvenile. If it's not, then you're going to be in the adult courts, and that record is going to be fully available. And lastly, I'd say that the records, and this applies, and I'm sure you all know this already, but it's worth mentioning, right? That you got to try different combinations of names, because you never know how the police officers, how the law enforcement officer actually wrote down their name at the time of arrest. So specifically for people that have two last names, that have provided two last names at the border, and may have some type of identification with two last names, local officers may not know how to quickly record that, and so therefore you want to try a different combination of names if you're doing a name search in that particular way. The process, I would usually just go and tell the client, hey, look, go yourself here. I would sometimes go with a client and maybe do a G28 and present myself to the state court and see if they can get the record in that way. The last thing that I wanted to just flag for you is that there are unofficial records sometimes that could come bite you, and you have to be aware of those. And I was thinking about two specific scenarios. One is the police reports. Police reports can have a wealth of information that may be utilized by DHS counsel, specifically if you're adjusting a status in court. We represented a kid who had been arrested, and the charges ended up being dismissed, but the police report was very damning, and we had to make sure that we knew what was in the police report in order to try to rehabilitate his character a little bit, because at the end of the day, the 485 is still going to be a discretionary benefit. And so therefore you have to make sure that you know the information that is in the police report. And I know that the probative value is not 100%. The court shouldn't necessarily be looking at it as the sole source for denying an application, but it's going to color the application and why take that risk. You got to know, you got to be prepared, know what you're going up against, so that you're able to present additional information that may be able to counter the information on a potential damaging police report. And the last type of case that I wanted to just highlight is school records. Sometimes school records can actually have an impact on these types of cases, even though they're going to be subject to the privacy clauses of FERPA. And again, students can obtain often their own records, and that can actually be a wealth of information to you. I'm specifically thinking about a case that we dealt with a couple of years back. This was when SIJS were still going to interviews at the adjustment stage. The kid had actually just carved a gang sign, and that he thought it was cool. He had no ties to gangs at all, so he wasn't a gang member. I wasn't worried about that. We interviewed him many times, and there was no signs of gangs there. But when he did that, the school officials actually referred him to the school resource officers, and the school resource officers wrote a report on it. That then sort of became sort of a law enforcement report, and we got interviewed about it, and he got asked about it. And so that is a very interesting a way in which school records, or what happens in schools, sometimes can make it into those records. You got to make sure that you are asking for those records under state law, specifically when it comes to the police reports and possibly school reports. Emily, I think Emily and I were going to go back to FOIAs because we know that FOIA requests are often redacted, and it's super frustrating because you have so many things that are blacked out and you want to know the information there. Emily, I'll let you take the lead on this and then I'll jump in.
Sure, thanks so much. All right, so here's the deal. If you have exemptions in records that you've requested and obtained from various agencies, you are going to have, in most cases, a tough time challenging those exemptions without going to district court, without going to federal court. But all hope is not lost, because I think agencies are not accustomed to advocates and lawyers and non-lawyers doing FOIA work being sort of savvy about FOIA. And so I think that we should all take the opportunity to push back in a way that is possible with resources and time on exemptions that we feel are unfairly applied. So I'm going to talk about a couple of them. When you receive documents from CBP or ICE, and they're maybe contained in the A file or separately through the open request that Raul was talking about earlier, you're going to see exemptions. Often you will see exemptions that are law enforcement exemptions, and that's exemption 7. And so what I'm going to do is I realize I'm looking at the time and realizing I don't want to get too in the weeds on the exemptions, but I will refer you, and there's a slide at the very end of this presentation about resources. The American Immigration Council's practice advisory, ILRC, also has a great advisory. There are other resources that go a little bit into the weeds a little more on the exemptions. So I think it might be helpful for us to do a quick overview, but just to remind you that these exemptions can be raised with the agency on admin appeal. You don't have to go to district court, and you can possibly win the war of attrition. So if you just keep pushing and you can potentially get some more documents. So I'll just say really quickly, exemption 7 is one you'll see a lot. That's the national security law enforcement sensitive documents exemption. And so for exemption 7 to apply, and you're going to see exemption 7C and exemption 7E. Exemption 7 broadly is about documents that are compiled for law enforcement purposes. And that can apply to civil and criminal law enforcement efforts. And so has been broadly applied in the immigration context, far too broadly. I think we might all agree. So for 7C, we're talking about law enforcement information that's expected to, the legal sort of phraseology is constitute an unwarranted invasion of personal property. So you're going to see, names of law enforcement officials exempted under this in some cases, guidelines, techniques and procedures, what they consider to be important techniques and procedures for law enforcement investigations or prosecutions. That's under 7C. And 7C is the personal property. It's not so important maybe to distinguish, except for to say all of this is when they think it has something to do in law enforcement and they don't want to disclose any of their techniques or procedures. I think one way to push back on exemption 7 is to say that the public interest is outweighed. So the revealing the information, the importance of that to the public interest outweighs the privacy interest or the government's interest in a government official's name or in some of the information that they might disclose. That's one of the arguments you can make. I think another argument is that these are not techniques and procedures that are not already known to the public. If something is already sort of known to the public, in one case I'll just highlight, which is sort of relevant here, was the 2017 ACLU case that talked about, questions at the border, questioning of immigrant minors at the border about their involvement in smuggling. So, the questions were asked when they were suspected of these minors of smuggling. There weren't really any special techniques being used, no special law enforcement techniques, no special methods or skills. And the children that were being asked the question weren't in danger of learning the technique, nor would that technique be revealed through a FOIA, FOIA document. So I think that like, just to sort of understand the context in which you are going to see this exemption, it's a really tough one to overcome. Courts and the agency obviously is very deferential to the invocation of this exemption. And I think similarly, you're going to have a lot of problems with exemption 5. That has to do with memoranda, policies, emails, analysis. You'll see this come up a lot in any emails that are being sent back and forth within an agency. Decisions also in terms of like asylum assessments, these sorts of things are redacted under V5 because they're considered the deliberative process is involved, so that, you know, some agency decision making would be revealed if those documents were uncovered. And so we wouldn't want to, you know, chill the back and forth and the decision-making process of the agency. So we need to redact that and keep that information from the public. That's a tough one to overcome too, although there's some arguments that you can make that not all of the information should be redacted. Some of it could be revealed. And that argument is called, you know, the segregability argument. So, while some of that you redacted too much, some of it should be made available. And you can sort of push back and say, why would 2 pages be redacted, or even a half of a page? Some of the information there is probably factual or should be provided. So I think I'll stop there. I think one thing to think about is there is a foreseeable harm standard, which means that even if these exemptions apply, the agency has to show that it will be harmed by them being released. And that there's too much to go into here, but if you are facing exemptions and thinking about how to articulate challenges, again, reach out to the council, consult some of these practice advisories, and you can pursue some of that in an admin and appeal process. You don't necessarily have to go to federal district court. And I'll turn it over to you, Raul.
Yeah, I just wanted to quickly highlight that another common one, we don't see it as much, but specifically if there are folks that have done a visa application in the past, you may see that B3, just because there's a statute that says that visa applications are not releasable under FOIA, and so you may see that one. I'll just add that. And obviously that comes into play because the 485 asks if the person has ever applied for a visa before. So I just wanted to highlight that.
So I want to sort of, maybe we should open it up to questions given the time, but I will defer to the coordinators of the panel on that one. And I will continue quickly to give an overview of the administrative appeal process. So, you know, this is just, you received a response to your FOIA request to USCIS or CBP or OBIM. The agency said, this is all we have, we're finished with you. In that sort of, or they have granted you, I mean, that's a grant. They grant your request, they give you documents, or they say, we don't have anything about your client. This also happens. And so we're denying your FOIA request, or we're saying we don't have anything, and this is our final response. Essentially, when the agency gives you their final response, they need to include the following, which is, you know, a determinant whether or not they're going to comply with it, or the reasons for the determination for the grant or the denial. And they have to say, you know, if you're unhappy with our request, you can seek out assistance. I think the reason this is important to highlight is because I think sometimes when you receive a response to your request, it's an interim response, or the agency, it's not a final response. They should have your appeal rights and all this information in their final response, at which point you have exhausted your administrative remedies. You don't have to do anything more at the admin stage, and you can go to federal court. If you don't ever receive a response to your FOIA request, and your problem is that it's just sitting and you haven't gotten anything back, I would recommend, I think we all should be pushing harder. So I think we should be reaching out to the public liaison for the various agencies. We should be asking for mediation assistance, maybe from the Office of Government Information Services. And again, come to the council if you're interested in pursuing and pushing harder at the admin stage, because I know that we don't have the resources to go to federal court. I think there are ways to nudge the agency to respond to the request. But the overarching point here is if you don't get a response, you don't have to wait. You don't get a response within the statutory time period. You don't have to wait, and you can go straight to district court. You don't have to appeal a non-response to your FOIA. And then the final slide. And then I've been talking a lot about litigation. I think this is a last resort, of course, but oftentimes if you were seeking information, you're just not getting it. If you file a complaint, a very simple complaint, which does require you to pay filing fees, and to be admitted or in a particular federal district court, or to have co-counsel that's admitted, then you can, you hopefully will get a response relatively quickly. Again, this is not for FOIA. For some of the requests that we've discussed today, they're outside of the Freedom of Information Act. So ORR records requests, the EOROP records request process, that's not what we're talking about. We're talking about FOIA requests that under the Freedom of Information Act, it's very straightforward. They violated the statutory time frame and you would like your documents, please. And they likely will move on them. Whether or not they will move on them any quickly than if you've waited for the 3 months, I would say that you need to leave a couple months for the agency. The agency has 30 days to respond to your complaint, but you may receive documents more quickly. I'd say 1 to 2 months. If it's a fairly straightforward FOIA request and you just haven't received the documents and you really need them, I think litigation might be a good option. And I'll stop there.
Thank you guys so much.
Go ahead.
Sorry, go ahead. We do have some really good questions that have come in. We have a couple minutes, so I will just start with one here. So this is a question about OBIM fingerprints. OBIM records, are they limited to fingerprints taken at the border, or do they include when biometrics are done later? And they're asking because they have occasions where clients do not remember if they've been fingerprinted. So is it better to just do a FOIA request to USCIS for the A file in that circumstance?
Yes. I think no. The OBIM ones that I've seen at least have been very specific to border encounters. For other biometric captures, I think at the very least we've seen the notices that are part of the A file. We've seen other types of records be part of the A file as well. But yeah, for the records, I would go to OBIM mostly when you get when you want information on a border encounter. Emily and Dora, do you have any other additional thoughts on that?
I agree with that. What was specific about the fingerprint, the timing of the fingerprint? I'm not sure I know the answer to that, but maybe we could.
I think they were wondering if doing a fingerprint, doing the OBIM will give you anything besides the crossings at the border.
Yeah, I agree with Raul.
Great. So do you know how long it will take to receive the record of proceedings from your request?
What I have seen is that it's a couple of weeks, but I'm sure that varies. And again, that's something I'd be curious to hear more about. That is absolutely one of the problems that has been raised, is that there is no time frame in which to respond. And so while I think folks we're happy to bring this out of the FOIA process because it just sort of streamlines things. And I do think that has been a concern. I don't know, Raul and Dora, if you've heard differently, but I've heard within a couple of weeks, 2 to 3 weeks.
I've heard some practitioners say that they've received it quicker than that, and they've received it via ECAS, and that's another issue as well.
Right.
or it's actually being exchanged electronically. So just be on the lookout for that.
Right.
Let's see, we have some other really good ones. Do the panelists have strategy tips for doing record requests while avoiding providing admissions or evidence of alienage for when children may eventually be seeking something that they're trying to do termination or suppression?
Dora, does that come up for you in the ORR records request context?
I will say my my team that we often do not carry out a termination strategy for these kinds of cases. So I'm afraid I do not have feedback for this, but I'll be happy to consult with my team once more.
Yeah, I mean, we talked a little bit about it earlier in terms of, I mean, I don't think there is ever a requirement that you provide any of that information. You should be able to FOIA, whether or not there's some back and forth with the agency, that may be, but rest assured that that is not something that is required. So whether you file it, you file your own written request or just leave that information blank in forms, I think that, I didn't realize that's general advice, but I think that it's not required.
Right. I want to be cognizant of time. So I'll go ahead and turn it back over to Serena to wrap up real quick.
Yes, thank you all so much. We are pretty much done here. I just wanted to give a quick flag to CILA's pro bono platform. There are links here. And then, please stay connected with CILA and recognizing we are over time, but thank you all again so much, and especially to our guest speakers today. There was such great and such helpful information here. So as we close out, there should be shortly some links in the chat to the two surveys that we mentioned. So one is for feedback on this training, and the other one is to request CLE credit. Thank you everyone again for joining us today, and have a great rest of your week.
Thank you.